Good morning all to the webinar of Mehta Mehta. Thanks for all you for participating and sparing your time. As usual, I tell that this is webinar not for showing the knowledge, but sharing and chit-chatting and encouraging everyone to participate and be part of this knowledge webinar. Today, we have a topic of reduction of share capital, and we have a great two stalwarts from the industry, one from employment, one from practice. Both are master blaster in their own field. We have Mr. Ambar Gupta and we have Mr. Yogesh Chande with us, and both are excellent in their own field. To give brief introduction, but I'll be telling that Amber, your profile is so long. I will have 15 minutes on webinar on your introduction only. Such a big profile and so many achievements. Thanks a lot. Congratulations for your career.
Thank you, ma'am. My introduction, Ambar Gupta at Capital, Birla Capital is more than enough. So much. Thank you.
Oh, he got so many awards. He has done so many courses. He is basically CS and LLB CS, I will add, because our professional colleague, he is leading a legal profession in his own area. Amber, to give a short profile, Amber has 22 years work experience in the field of legal, compliance, regulatory, company secretarial function, security, capital markets, and insurance law, banking, NBFC, IP. And since he's our old friend, I must say that, and since long he is in this area of practice of secretarial and legal. And we have another profession, our colleague. Amber has won several awards and he is member of CI also, and he is presently working as a head corporate legal company secretary and compliance officer, Aditya Birla Capital, the holding company of finance service business of Aditya Birla Group. And he's been associated with that group since 2008. And Amber, I'm shortening your profile. Please give me for that.
Ma'am, that's more than enough. Thank you so much. I think.
Thanks a lot. Thanks a lot. Now, thanks Amber for joining us. And now I would like to introduce our another panelist, Mr. Yogesh Chande. I would like proudly our professional colleague. He is basically a Bachelor of Commerce, LLB, LLM, and also CS and CA intermediate. He has admitted practice in India with over 2 decades of transactional experience, concentrating on mergers, acquisition of listed companies, delisting of listed company, fundraising by listed companies, and security regulation governing Indian capital market. He spent almost a decade, among others, with India's leading stock exchange, NSE, investment banks like Ambit Corporate Finance, ICICI Securities, and Centrum Capital. He has advised on various public takeovers, delisting, company buyback, public offering, and private fundraising. Currently, he is a partner with Ms. Shardul Amarchand Mangaldas, advocates and solicitors since 2015. And he has given some of the recent transaction advisory on Kubota Corporation from Japan, Anupam Rasayan Limited for acquisition, and advised on Sony Pictures merger of Z Entertainment. Welcome, Mr. Yogesh. Thanks for your timing, and we welcome you and would like that you share your inputs. Welcome both panelists.
Thank you so much.
Welcome, Mr. Bala, for your time. As you know, Mr. Bala, sales by. Friends, today's topic, reduction on share capital. People know reduction on share capital, but the most crux of the reduction of share capital is why and when and where to use it. That is the more important part of reduction of share capital. And there I will advise all participants to use your chat box to get the knowledge from our experienced, knowledgeable panelists. And as regards process, we are going to cover in that. The participants are advised to put on chat, and we'll take parallelly the chat box as and when the questions crop up, when the matter is going on, the slide is going on. I'll request both the panelists, first Amber and then Mr. Yogesh, to give brief on the topic, brief you on your view on the topic, and then Mr. Bala, and then Dweep, you can start the presentation. Over to Amber, and then Mr. Yogesh. Thanks.
Thank you, Dipti madam. Thank you, team. Am I audible?
Oh, very much.
Yeah.
Thank you, everyone. Very good morning. Thank you, Yogesh Chande, my co-panelist, Mr. Bala, moderator, and presenter, Mr. Joshi. Dipti madam has already given you a brief introduction about today's topic. And as you know that the reduction of share capital is one of the provisions which are there under the Companies Act, which provides you a methodology for reduction of share capital. There are various ways, as you know, share capital can be reduced, buyback, redemption, and also to redistribute certain assets back to the shareholders, or to discharge liability for an unpaid up share capital. Some of them, reduction of share capital is also used as part of restructuring program also during merger, amalgamations, etc. Interestingly, the old Companies Act also had similar provision. The new Companies Act 2013 has carried forwarded most of that provision. Of course, the major change has been the Nclt provisions, which has taken over from the previous Companies Act. So most of the procedural requirement is like old provision in the new water kind of thing. And you can refer section 66, which is the main section, followed by the procedural part under Nclt procedure for reduction of share capital rules 2016. The presenter for this topic, Advocate Joshi, will be taking you through the procedural part, so I'll not be touching those aspects. But couple of things which are very, very critical when you are looking at the reduction of share capital more from strategic point of view is, of course, the valuation of the shares, which is the most important. And now all the valuation of the share, as you know, will be done by an independent registered valuer. So you have to be very, very careful in terms of when you're going for a valuation, because that would going to impact a lot in terms of the approvals that you're seeking and disclosures. Second is, of course, the tax implication. Some of the tax aspects, of course, your finance team would lead that, but very important to take into consideration and how you're going to disclose those impact and the treatment. That has become very, very critical. Third is, of course, in terms of how you build a scheme. The entire scheme drafting becomes very critical. Normally, generally, we have seen that many times it becomes a copy paste for scheme, and they just, but certain elements, aspects, important aspects, sometimes people forget to include, which may create issues during tax assessment later on. So it's very important that the scheme of reduction of share capital is properly drafted. I have also seen in one or two my experiences that when reduction of share capital is being done, and you have separate reduction of capital for equity, you have separate for preference shares, and also if you want to do reduction of share capital to wipe off your accumulated losses from your share capital or from accumulated profit and losses, those treatments, those disclosures, and those aspects has to be seen a little differently. And some of the opinions that we have procured is that some of these aspects has to be captured separately in a separate part rather than just to be in the main part from taxation point of view. So these are some couple of aspects. And of course, if you are a listed company, then please be conversant with the regulation 37 of the SEBI LODR, which needs to be followed in terms of taking the approval of the stock exchanges and filing the scheme, etc., and other disclosures. So that's a very very basic overview in terms of the background. Procedural part, Mr. Joshi will take care of, and maybe we'll be happy to answer some of your queries. Over to you, Mr. Chande.
Yeah, thank you, Mr. Gupta. Nice of you. So, am I audible? Because if somebody can.
Very much.
Yeah, thank you so much. So predominantly, I will try and cover the aspects or the structural issues involving listed companies and the regulatory issues around capital reduction. First and foremost, we keep hearing the terms interchangeably: capital reduction and scheme of arrangements. So one question which often comes up, that whether SEBI circular governing schemes at all apply to Section 66 schemes to begin with. So rather Section 66 capital reduction, as opposed to merely 230, 232. We can discuss that further. I will also take you all through, and would love to hear your experience around selective capital reduction, minority squeeze out, optional capital reduction, and how to go about in a closely held company where shareholders are not traceable at all, and how to reduce or squeeze out them and try to achieve status of a wholly owned subsidiary of the holding company in such situations. So over to you, Pala sir. I mean, nothing further to add, and we'll layer on as we go along. Thank you so much.
Good morning to all of you. I have a pleasure to welcoming you all on my own behalf and also on behalf of Mehta Mehta for today's webinar. Today's webinar is a very, very important thing for any company secretary in the employment as well in the practice. Because reduction of the share capital, when we talk about it, is nothing but it is just a trimming of the share capital structure in a company. This trimming can be done for many reasons. One thing, we want to enhance the shareholders' wealth creations. So company is a good company. They have surplus capital. They want to return the money back to the shareholder. That is one of the things. As some of our panelists said, the buyback, that is there. These are all done. And apart from that, the companies, when it is a loss-making company, when it is gone in the loss, the value of the asset with the company is having it is not really representing the value. In such a cases, that company wants to reflect the right situation, and there also writing of the losses and bringing down, giving a realistic picture of the company, the reduction of the share capital also can be done. But whatever is required to be done, everything is having a regulatory aspects. Nothing can be done without getting a proper approval. Earlier, which used to be the court, now it is actually a Nclt. So one thing is very, very clear in the whole aspect is everything is put to be in a scheme. The scheme document has to spell out each and everything. If something is missed out, then it's a problem. That is the crux of the matter. We have a eminent panelist today who are actually in the practical field, who has handled the virtual cases. So I am very confident, whatever the queries, whatever the clarifications, whatever the doubts we have, we can have the expert advice from them. They will be happy to share their knowledge to us. In fact, way back 30, 40 years back, when I used to travel from Pune to Bombay, I have seen the companies which actually used to put the company's name. After that, in the bracket, they used to put unreduced, which was actually the older provision, the Companies Act, which has been subsequently got away. So that's it. Nothing more I want to add at this subject. Without wasting my time, I'll ask the presenter to start the presentation. We'll give the enough time to our panelists to have our knowledge enhanced. I'm looking forward adding knowledge in today's session very much on this subject. Thank you.
Hello, is my voice audible?
Yeah, very much audible.
Yes. Hello and good morning all to all the viewers, moderators and panelists. So today's topic, as briefed by all the panelists and everyone involved, starting with our topic, reduction of share capital. I would just like to brief you up with certain, basics of the reduction of share capital. I'll try to, quickly run through the process and also the whole, the basics of the reduction of share capital in order to, fall out to the last when the legal issues and the other aspects with regard to valuation or with regards to, as, given by the panelists itself with regard to tax implications and everything can fall through. So starting with this, I'll just yes. So starting through reduction of share capital basically is one of the modes of corporate and the financial restructuring, which has been widely used. Secondly, it enables a company not only to recognize its capital, but also to in many cases to wipe off or to write off its accumulated business losses from its balance sheet, getting cleaned up basically. So by writing off an equivalent amount of share capital besides it. Then one of the two major methods by which the company can do this reduction, the company does this reduction of share capital, is one of which is where it can extinguish or reduce the liability of its members, or by paying off any uncalled capital, or it can repay to them or to the nominal value of shares. Secondly, when the company is in suffering for business losses and accumulated business losses, in that case the company can cancel the paid up shares as they are unrepresented by the available assets. So basically these are the two modes wherein, as an illustrative to section 66, there are certain modes that have been given which are illustrative in their presence but not exhaustive. So to start with, reduction of share capital, the needs and everything that is included, the various reasons and needs for reduction of share capital being, firstly, for eliminating accumulated business losses, returning of surplus to the shareholders, maybe as a part of the scheme of compromise or arrangements, releasing a liability to pay up capital, and simplifying the capital structure, insufficient distributed reserves, or distribution of assets to shareholders. So these are certain, reasons, or you can say the needs for carrying out such capital reductions. Coming to the regulatory framework on, so basically the regulatory framework was on 7th of December 2016. The various provisions under sections of Companies Act were notified. One of which turning out to be reduction of share capital, section 66 was notified. Along with that, Rule 226 of National Company Law Tribunal's procedure for reduction of share capital was also notified, and other provisions which govern the working and the style of reduction of share capital, being 230, 242, Regulation 3711 of SEBI LODR. Coming to the crux, section 66 of Companies Act 2013, it basically only tells out or makes provisions for application to the tribunal by the company, being limited by shares or by limited by guarantee, and it also sets out the modes of through which the reduction of share capital can be given. As I was saying, for this same thing, the modes that have been given under section 66 are only an illustrative mode of carrying out this the reduction of share capital, and not an exhaustive list through which the same can be carried out. If we just emphasize on the wordings of the section 66 itself, it says in the last line of the reduction of share capital in any manner and in particular. So basically, when they have given the liberty by saying or by introducing the words any manner, it leaves an open end for the company, for obvious reasons, by complying to the conditions as required under the reduction of share capital. It can carry out such reduction of capital in any manner as the majority of the shareholders deems fit, until unless they are being fair and equitable to the other minority shareholders. So modes of reduction of share capital, I'll just give you a brief as to what are that illustrative modes of reduction of share capital given under section 66. One of being extinguish or reduce the liability or any of its shares in respect to the share capital not paid up. So basically what this says is, now if supposedly you have one share of 100 each, one share of 100 rupees each, and 75 has been paid up, the company may reduce them to 75 fully paid and thus relieve the shareholders from liability on the uncalled capital. So basically they will be making those shares as fully paid up, and they don't have to pay anything extra to make sure that the shares have been fully paid. Secondly, what the other mode is, cancel any paid up share capital which is lost or is not represented by the available assets. For example, now if there is a 100 rupee share and which is represented by 75 value of assets, so 25 is represented by the amount of assets that have not been represented for that INR 25. So for that, they can cancel out those 25 rupees per share, standing out at only 75 worth of assets. So basically they're cancelling that paid up share capital. Thirdly, pay off the paid up share capital, which is in excess of the needs of the company. This may be achieved by that, I mean, without extinguishing the reducing liability by, if there are 100 fully paid shares, that can be reduced to the face value of INR 75 by paying back INR 125 per share. That means that companies in excess of its surplus at a surplus or the capital required by them. So in order to, reduce those surplus, they can come out with one of these methods to, reduce the share capital. Coming to conditions precedent, I'll just come. So firstly, the company is not allowed to implement the scheme unless there is a repayment arrear in case of deposits being the principal amount or the interest amount. Secondly, the shareholders of the company should approve the reduction. Not only the shareholders, but also the board resolution, for the obvious reasons, should be there as a condition precedent. Thirdly, the company should have power in the article of association for the reduction of share capital. This being the major, there are also been judgments placed, and that is a well settled law for the matter in Dexine Patent Packing and Rubber Company, wherein it was very clearly said that for a company to reduce its share capital in any manner set out in the section, it must have given power to it under the articles to do so. And authority given to do so given by the memorandum of association is of no avail, which means that even if the MOA speaks of that, but AOA has to specifically introduce that power to the company, stating that they can carry out this reduction of share capital process. Secondly, also, yes, ma'am.
Dweep, there is a comment by that number of shares can also be reduced. Yes, by Mr. Mehta Mehta. And
Yes.
there is a question: can reduction is used to extract excess cash available instead of dividend?
I didn't get the question. Just a minute.
Can reduction is used to extract excess cash available instead of dividend?
Wait, what is the question? Extract of excess cash means what?
Yeah, if I can take that, Yogesh here.
Yeah, please, okay? Please, to panel. Yeah, please.
Yeah, so yes, the answer is in positive. See, let me explain. Yes, to answer, this mode can be used to extract cash as follows. Buyback, for example, leads to extinguishment of capital, but there are various do's and don'ts around buyback of shares. If you were to go down that route, the limits in a financial year, the quantum, etc., and all. However, therefore, under section 66, or if you were to go down the route of 230, the extract cash lying in the balance sheet can be extracted and to be paid out, or it will be considered as deemed dividend from a tax incidence perspective. And therefore, that's the great advantage and arbitrage available if one were to go down the capital reduction route as opposed to pure buyback of shares, which is otherwise regulated and governed pursuant to various rules, regulations, whether you are listed or unlisted.
So that
I hope that answers the question.
That means you are entering in the compromised arrangement with the shareholders and returning the excess cash which is available with the company.
Exactly, sir. So you are right. Yeah. So the way to structure it is not under section 66, but to go down under the 230 route.
Yeah, 230. Because earlier it used to be 390, 394. Now it is under 230.
And therefore,
I think in the past also there were many companies, overseas companies, who doesn't want to see the paper currency, that is borrow share, who wants to see the real color of money. This has been done. Yeah.
Correct, sir. So yes, I mean, I have had privilege in past to advise, as you rightly said, certain listed MNCs, including.
Yeah, they wanted to see the color of the money, not the paper. That's right.
Correct. Yeah. So yes, you can extract cash. It is a perfectly legal means of doing so, and avoid getting into the nitty-gritties and rigidity of buyback provisions.
Only thing is you have to undergo via 230. Not under section 66.
Aditya, go ahead.
coming to the rules, as as notified along with those provisions section 66. The rules I'll be covering majorly in the process part. So I would just rather, move on with that rules part along with the process itself. So coming to the process, the step one, the first initial process is as per the panelists that they rightly said, that the preparation of draft scheme, it is a vital importance while starting of the process, that the scheme should have all the provisions with regards to any implication with regard to tax assessment, valuation, and everything should be taken care of with beforehand itself, and in the draft scheme itself. So firstly, the articles of association should be having the power to do that. Then if it does not have, the articles do not have, then the alteration of articles as per section 14 would be there. Then basically the convening of the board meeting for the following purposes, which being the draft scheme of the board of directors, calling of EGM of shareholders of the company, and approval of notice of the EGM. Secondly, being the holding of general meeting and passing of the special resolution passed, and filing of the MGD 14 within 30 days of passing of the special resolution. Thirdly, the main part comes into which is when the filing of application with Nclt comes in. So now what I'll do is, instead of taking you all through the theoretical part of it, I would rather share the forms of RSC 1 or the other forms. So you can have a broader look as to what does it look like practically. So I'll just start sharing my screen with regards to RSC 1. So here the company shall prepare an application for reduction of share capital in form RSC 1, mentioning the details about the applicant jurisdiction. So we can just have a look through that also. So this is what form RSC 1 looks like. As we know that Nclt follows a pro forma based application of the petition process, and this is what the application looks like, wherein the details of the company, the registered office, the objects of the company, the capital with which it is registered, and the paid up share capital, everything has been given. The powers given under the article of association has to be mentioned out here itself. Brief information with regard to the financial position, and also with regard to the reasons to be carried out, reasons why this reduction has to be carried out, has to be mentioned here itself. Then the details with regard to the special resolution passed on which day, and the details with regards to the number of members who voted for and the against, and also if there is any extinguishment of liability with regards to any unpaid share capital with regards to the members, so that also has to be specifically mentioned in the petition itself before setting out those petition for the application. Also then comes part of the prayers, the form of minute proposed to be registered under 66. So this is what the resolution that has been passed, that needs to be minutized, and then that needs to be registered under section 66. So in the final order, you will find this minute being registered under section 66. Then the prayer clause comes into picture. Then the attachments. Here are the brief list of attachments. So I'll just start sharing my just a minute. In this, these are the detailed list of the documents that are required to be attached to the current petition, which can be list of creditors, the certificate from the auditor, that the list of creditors fine, the declaration of the solvency of that, the repayment has been made, and everything, the deposit with regards to the same. So these are the detailed list of documents that needs to be attached to it. I'll show the next slide. After this, we come up to the process wherein once the application or the petition has been registered with the Nclt, when the hearing takes place. So then after that, when the Nclt takes up the process, the first thing that the Nclt would do, just like in the matter of merger or the scheme of merger or amalgamation, is the same thing, wherein the tribunal shall, within 15 days of submission of the application, give notice or direction to three parties here, one being the regulatory authorities, second being the creditors, and the Security and Exchange Board of India, SEBI. No, I'm sorry. Is there anyone speaking?
No. Last part.
Okay. So these are the regulatory, service of notice given to three parties. If one central government and the ROC shall be given in RSC2. The SEBI also shall be, in case of listed companies, will be given in the form RSC2. I'll just share RSC2 and RSC3. Just a quick. So this is a form where that goes to the central government and the ROC and the SEBI in case of listed, wherein the capital that has been there and the post reduction that has to be specifically mentioned. Then they have to also make provisions that if there are any objections being filed by them, so that should be filed within 3 months from the date of receipt of this notice. So basically they have a 3 months period wherein they can file their representations or objections with regard to the scheme to this notice. Same in a similar way in RSC3 where the creditors of the company takes place, the notice to the creditors has been sent. So are you able to see the screen here?
Yeah.
Notice to the creditors? Yes.
Yes, please. Yes,
So
please.
this is also the same thing wherein the date of when the petition was presented to the tribunal has to be informed. The current capital and the post reduction capital has to be specifically mentioned, and the nature of debt or claim to be stated here. Then if you have any objections, that the same thing wherein they also get a period of 3 months to object or make any observations with regards to the scheme, and accordingly they can send their responses.
The creditors will be as on the date for entire list of the creditors.
Yes, the record date and everything.
Irrespective of secured and unsecured.
Correct.
On the given date,
Correct.
what are the names appearing in our ledger?
Correct.
Those are the creditors.
Correct. That has, as per what what has been presented before the tribunal.
Yeah.
As per the record date or whatever fixed.
Yeah.
All right. So, secondly, we come to publication of notice. The tribunal also asks the petitioner or the applicant to also present the same notice to the newspapers. Basically, one being in the English and vernacular language. If you want to share, I will see this. I'll just share quickly the. So this is basically the public notice that looks like, wherein all the details with regards to the same has been, and any of the objections, if any, can be given to within 3 months. So you're able to see the screen, the PPT?
Yeah.
Yes, all right. Then the confirmation of publication of notice. Once all the service has been made to the creditors, being the regulatory or the regulatory authorities and the public through the newspapers, then the company needs to file an affidavit in form RSC5 stating that all the dispatch and the publication of notice within 7 days from the date of issue of such notice. Means that as soon as the notice has been served, as soon as the same is done, then within 7 days of that publication has been done, the company has to file an affidavit before the Nclt in RSC5. That comes here. So this is what an affidavit then looks like, where you need to attach with the proof of records, proof of dispatch, and the publication notice done. The next stage that we come on is representation by the regulators or by the ROC, SEBI, and creditors. So this comes up wherein the regulatory authorities, if they have any objection, then within 3 months they shall send that objections or representation, any of them within. So once they have sent it, the company is under the obligation to reply to them within 7 days of expiry of the period up to which the objections were sought. So Nclt then may hold an inquiry on adjudication of the claim or give direction for securing the debt of those creditors whose objections have been filed, or with any of the defaulting with the regulatory authorities being there. And if there is no representation as such made, then it shall be presumed that they have no objections. The next stage that we come on is order by the Nclt. The order confirming the reduction of share capital and the approving of the minute shall be in form RSC6. So this is where the order comes in, wherein, let me just share the screen. So this is the proforma which the standard proforma which the Nclt issues the order in, wherein it will be representing the same, that the notice of the date of the hearing of the petition has been given to this, wherein there has been received any objections or representations by any, so that can be recorded here. Then they are if whether they have been secured or whether they have been given a valid or justifiable exit route here, or everything can be recorded here. And finally sets out that the company has been registered under section 66, and they also minute as approved to the register of the companies within 30 days of receipts. Also, one thing to be noted here is that as soon as the same is done, the words "and reduced" are to be added only where the orders are direct. So basically, whenever the company is publicating in any of the notices with regards to regulatory authorities or in public, they have to use along with their name "and reduced." So basically that signifies or shows that the company has recently entered into a reduction of share capital. Then step 7 is only the filing of the form ROC with the order with the ROC, where the company shall deliver a certified copy of the order to the ROC and file form INC 28. The same certificate that the registrar issues under section 66 will be in form RSC 7. So this is basically the whole process that this whole process takes about 7 to 9 months as per the given standard. But now looking at the current the status of the NCLT and its time consumed, I believe 7 to 9 months is practically a very being very positive about it. But no, 7 to 9 months is not a realistic approach. This may take a bit more longer, and the litigation part again that comes in.
One small question I have with you.
Yes, sir.
In case of the company which is going for the capital reduction scheme,
Yes,
if there are a couple of show cause notices have been issued by the ROC,
correct.
the company has not actually gone in the compounding process, can the ROC insist the first thing the compounding is required to be done, then only they will have no objection, or it can be stalled?
Yes, obviously. So the main reason for those objections would be to clarify them first, basis that what were to reply to those show cause notices first, and then eventually once they're satisfied with regards to the same, they will then make a representation before the tribunal that they are satisfied with their reply and the same has been taken care of. They might as well appear before the court at the tribunal itself objecting to the same. So there satisfactorily the company has to answer to those claims by filing a reply or by whatever means. So that is one of the aspects. That is why the SEBI and the ROC has been given a role wherein they have to be served a notice.
Any non-compliances which is there, normally ROC does not
correct.
No objection. They heavily come back, and even I have seen actually. Even the show cause notice reply, they are not satisfied. They say you go for the compounding. Once the compounding application filed, then we'll give the no objection certificate.
Correct.
That is what it has been happening.
Correct. So, but now if we look at in the similar manner, if we look at scheme of merger or amalgamation being filed in the application, so ROC has its say in it, wherein ROC has to file a reply once the tribunal is satisfied with those observations being made, or we have given an assurance to the ROC that we'll settle out this matter by whatever means, by being be it compounding or be it any other way is possible there, depending on the circumstances of the situation. So there the ROC files its reply, and then once the ROC is satisfied, the tribunal is satisfied, that is when the tribunal then orders for the second stage of approval for
you are absolutely right, because I was working with some merger and amalgamation scheme.
Correct.
Where in the company which was amalgamating, there were show cause notices, but the scheme has actually said the surviving entity will take care of the things. But ROC said surviving entity can take care of it. Before that, you file the compounding application. Everything is done. Once that is done, then only it can be done. Otherwise, it is not possible. So again, the company has to spend time, sorting out all these issues.
Simultaneously taking care of this aspect also. But in the meanwhile, they can always, make an application to the tribunal saying that this has been taken care of and this is in process. So rather not, hold this matter up for this particular aspect itself. And if they can, if then that is the tribunal's total discretion as to allow that application to be carried forward, seeing the materiality of that default.
Amber here, just wanted to add that, as you know, there are several judgments also delivered by orders delivered by Nclt, and they have held that, reduction of share capital under 66 is more of a domestic affair between the company and its shareholders.
Correct.
So far, it does not, if the reduction of share capital is fair and just, and it does not create any fraudulent aspect, ideally, there should not be a challenge. But as Bala sir has rightly said, ROC tend to definitely have a say, and they do issue show cause notice, etc., and those needs to be satisfied. But yes, if some for reason NCLT rejects the application for reduction of share capital due to some of these reasons, that at appellate level, I think there could be a good case to argue on certain these aspects, because ultimately it's between the shareholders and the company. Number one. Number two, small companies, private companies, unlisted companies, as of where you have a large unsecured creditors, etc., there might be a good strategy to pay off these small creditors before the date you have fixed. So that when you are preparing the entire list of creditors, it's a very short list, or you have very limited number of unsecured creditors. That expedited the entire procedure. Just 2 points I want to add.
Yeah, that is the practical tip Amber has given. And as regards compounding and that not default, we can say that yes, legally everything correct, but one wants to expedite entire process. So if you are going for this kind of corporate action, better you check the compliance and correct it beforehand. So once the process is started, you don't have any hiccups. That can be the practical way of, right? Okay, thanks.
Absolutely correct. Absolutely correct.
Not only that, in one of the companies which was actually merging, then they said we'll be filing a compounding application, etc. This, that, etc. They said forget about it, the company will be taken care of the surviving entity. But what about the directors? Once the company get merged, the company is actually no existence, and directors we cannot take any action. So first thing is you have to file the compounding application in rest of the director, that it be put in the process, then only we will allow. That is the way they insisted by ROC. So anyway, regulatory people are all taking a little tougher stand there. So we need to ensure this thing before we get into the scheme. That's what it appears to be. Simultaneously, when you are processing also, it takes a little longer time if we have these issues. Yeah.
Talking about the regulatory aspect of it, as specified by Mr. Amber here, the additional compliances for listed entities and the intervention with regards to SEBI in those matters is inherently so huge that the pre-2013 era, in 1956, SEBI wasn't given the power. However, now as per section 66 subsection 2 tells about a notice to be sent to the SEBI and the other regulatory authorities, it gives an inherent power to SEBI. Now, there was one major case law in SEBI versus Sterlite Industries, wherein it was held that SEBI had intervened, wherein a majority of shareholders had agreed to the scheme of reduction of the share capital. But however, there were some minority shareholders who did not even participate. They had no positive or the negative response to it. They had not participated. SEBI intervened in that application, saying that it objects to the same, and as long as the any of the minority shareholders does not give a positive agreement to this reduction of share capital, it won't allow this petition to move. The same was first in the Nclt. It was first, by the court said that SEBI has no power to it. But looking at this in the new Companies Act, Companies Law, this provision has been specifically given to SEBI, wherein if there are no dissenting shareholders, if there are no shareholders, wherein they have no say on it, still SEBI can intervene in those provisions, and then they say and object to the reduction of share capital on the basis that whatever the observation of SEBI is in that matter. So additional compliances for listed entities also with regards to LODR 2015 comes into picture, wherein regulation 37 talks about drafting of scheme and along the draft scheme and along with the fees to be filed with the stock exchange for no objection certificate. Firstly, then that no filing for now before filing the same with the NCLT, the as long as you don't get an NOC from the stock exchange itself, NCLT, you cannot proceed the same before the NCLT. The NOC has to be placed with the tribunal along with the draft scheme and the petition, and such NOC that has been given by the stock exchange would be valid only for a period of 6 months, after which the validity of that NOC also gets over. Then compliance with other requirements as prescribed by the board. During this process, there has to be certain other compliances which the SEBI appropriates, which has to be complied with by the company. Then upon scheme of sanction, submission of documents to stock exchange as prescribed by the board. So once the scheme gets approved, this document, there are certain documents that the SC would demand, the stock exchange would demand from you. So that needs to be taken care of. Then this provisions of regulations of regulation 37 do not apply to the merger schemes of wholly owned subsidiary with its holding company. Only a disclosure with regards to the same to the stock exchanges.
Dweep, 1 minute. There are a lot of questions. For panelists, from creditors' perspective, how reduction impacts them? Second, when there is certain percentage of objections from creditors is required for stalling the scheme by NCLT. Over to panelists. Shall I repeat the question? From creditors' perspective, how reduction impacts them? Second, when there is certain percentage of objections from creditors is required for stalling the scheme by NCLT.
As far as the creditors are going is concerned, when you are actually cancelling the share capital or when you are extracting the cash, etc., they are worried whether their outstanding will be settled or they will be running into the problem. That is their worry. That is why they come back and there is objection.
Panel, any view you want to give?
Yeah, Yogesh here, if I can take that.
And the only thing is they need an assurance from the company that their interest is actually protected and their payment will be prompt, etc. That assurance they will be looking forward. That is the purpose why they are raising their objection. As some of our panelists said earlier, in case of the small creditors, etc., and all these things, if they visualize some of the people who are raising the issue, it can be settled. Yeah.
Dipti, Shailesh here, Shailesh Rajadeksha. Dipti, I feel that creditors are affected only in that situation where there is a cancellation of uncalled capital. Where there is some uncalled capital, partly paid shares, and you cancel that uncalled capital. There only the share, I feel creditors are affected. Otherwise, if the shares are fully paid up, I do not see how creditors get affected.
Yeah, Mr. Rajadaksh, Yogesh here, if I can respond to that. Am I audible?
Yeah, very much.
Yeah, please.
So you are right, sir. This is one example which you said that, but I'll give you another example. If shares are fully paid up,
yes.
What if I not only reduce the shares, I reduce the face value also, and I say out of 100 rupees, I pay you a shareholder or all of you 100 rupees or 50 rupees out of it. So creditors will also get impacted there where there is an effective cash outflow from the balance sheet of the company. And therefore,
yes, you're
the
right.
concern I as a creditor will come that, boss, whether my liquidity is affected going down the line, whether company will be near future insolvent or not. And therefore, it jeopardizes my interest, and therefore I will stall the scheme. I will look to milk the cow now and will want the company to pay me first prior to them proceeding further with such a capital reduction. Hope that helps.
Yeah, that would be the case when there is an actual payback of money to the shareholders. But if it is a case of accumulated losses and you do reduction of share capital to wipe out those losses, to remove those losses.
Agreed.
In that
so,
case,
Mr. So sorry to interrupt, sir. I got your point. See, let me put it this way. If I was a creditor, you were a creditor, in that scenario, you are right. As a creditor, I will not be worried about my payables to me. But the example which I gave you, I will be concerned about the payables. So logically speaking, creditors will not oppose in the example which you gave, but creditors will typically end up opposing or confronting where there is a cash outflow.
Yes, cash outflow and when there is cancellation of unpaid capital. In these two situations, creditors have definitely have got right to need to object.
Yeah, absolutely right. You're right. Absolutely, you're right.
Mr. Rajadhyaksha, one small point there. See, right to object. No,
not right. I used the wrong word. Sorry.
Yeah. Sorry. I don't mind. Yeah, because in India, anybody can oppose to anything. Me wearing black T-shirt. Yeah.
Not only
no,
that.
that's that.
No. When their interest is going to be affected, definitely they will raise objection.
One more point to Dweep. If we can go to the presentation, see, this is where I was trying to bring that nuance here. If you can go to step 1.
Just a minute.
I think for the benefit of the audience.
Yes.
See, here this I guess this steps are in relation to section 66, correct? Correct. The heading says draft scheme.
Correct.
See, there is no word scheme involved to begin with or used in section 66. It is application, quote unquote, as opposed to scheme word used in 230.
Correct.
Because so first and foremost, from a structuring perspective, you need to decide which route you want to adopt, while the end result, the effect is capital reduction. But whether you are going down section 66 route versus section 230 route, that is second. So therefore, this flow of steps are merely in relation to section 66. Correct? Am I wrong? All right. That is one. Second, one nuance here. Again, from a structuring standpoint, the biggest difference, the way I see between 66 and 230 is as follows. In 66, the application to NCLT is post the meeting, unlike 230, where the scheme is first filed to NCLT and meeting is convened under the supervision of NCLT through the chairman.
Correct.
From a listed company standpoint, in my 24 years, I have never ever seen at least listed companies going down the section 66 route. There may be some aberrations here and there. So the point I'm making is, first and foremost, decide which route you want to adopt.
Correct.
According to me, if you ask me from a smell test perspective and to avoid litigations and avoid disputes and avoid media attention and proxy advisory and where everybody will come and throw stones at you while you are in this, the advisable route is 230 as opposed to 66. So I just wanted to clarify this. Thank you so much.
So glad about
So you get NCLT permission first, so no one can point the finger there.
Yeah. So Dipti ma'am, yeah. See, I mean, pointing finger, anybody can, quote unquote, can do anything and everything under the sun. But the point I am making is, there is a third empire, which is the NCLT. There is a chairman who is conducting the meeting, as opposed to 66, where meeting is already held. And if I am the shareholder, I can start throwing allegations that meeting was not conducted properly, etc. Blah blah blah. Lunch was not served, dinner was not served, and all that. Yeah. So people can start throwing allegations in a 66 scenario as opposed to a 230 scenario, while nothing prevents anybody to allege anything even in a 230 route. Thank you so much.
correct.
Yeah, just wanted to add one more point. In fact, when you file reduction of share capital as part of the reorganization or restructuring under 230, 232, it is also advisable, and many times you can also add a clause that this particular reduction of share capital or reorganization of share capital as part of the restructuring is for purpose other than section 66. So that is certain practical aspects when you are drafting the scheme under 230 and 32, not under 66. Just to distinguish clearly that it completely falls under the purview of 230 and not under 66. And also in case of small companies, there are certain sometimes.
Second question.
Any period up to which the word unreduced has to be mentioned by the company.
It will be mentioned in the order, right, which NCLT will grant. Generally, all such order will necessarily mention, forget about 66. Even if you look at scheme of arrangement, come amalgamation, the order will always direct whether the word reduced has to be included or not. It will never be silent. So it will state that, and that's how you will have to execute it.
But the question they are asking is up to how long period one has to mention? Lifelong or some period or something? That's what I understand from the question. Because it is saying any period up to which.
Up to which, sorry.
Yeah.
My bad. So I think the way to do it is, first and foremost, most schemes will typically have a prayer that we do not wish to have the name in brackets and reduced. Having said which, even if it is insisted that you have it mentioned, your prayer in the petition should state that it should not be for a period exceeding so and so period. That's how it will work. But there is nothing codified around this unless I'm missing something.
Bala,
yeah.
in the case of buyback,
yeah.
And when you compare it with reduction of share capital where you have got excess funds and you want to return the share capital, for buyback you don't have to say and bought back or something, no?
No.
But
no,
here
no.
you have got to say and reduce, although the circumstances are more or less the same. In a particular instance that we have got surplus cash, you reduce your capital. In buyback, you have got excess cash, you buy back the shares.
Correct,
but here you write and reduce, there you don't write and bought back.
I think is reduced. I don't know because I have seen this unreduced somewhere around 25-30 years back. There were many companies, they were using it unreduced.
Yes, correct.
But in the recent months, I am not seeing any company using this reduced.
So as Mr. Chande said, they might have, the persons may be putting in their application that, look here, we are doing this not out of great difficulty that we have made losses, etc., etc. So why do you want us to add? And the court or the NCLT now may be agreeing to it.
So peculiar to this instance, we had one application made wherein such a prayer was allowed on the basis that there was surplus already there.
Exactly.
So to not grab such media attention or to do that, the same prayer was allowed.
So Dweep, yes. See, basically, this concept of end reduced is to basically indicate the public at large that this company is in distress. There are liquidity issues in near future, etc., which may arise, as opposed to a company which is in pink of health. And therefore, a waiver is generally granted for usage of the term and reduced in a distress scenario versus where company is not so in trouble. There is one more question, if I can take on that. Somebody has asked, and I think we answered that earlier, that how is capital reduction different from dividend? See, dividend versus buyback versus capital reduction. In a capital reduction, and I mean capital reduction under 230, where you can perhaps do anything under the sun. It is a single window clearance, so to speak. Unlike in a buyback or a dividend, in buyback, obviously there is a reduction of capital also. Unlike in a dividend, where there is no reduction of capital, but there is an exclusive regime governing, regulating buyback and dividends, unlike a capital reduction. So I think that's the basic fundamental difference. There is no rocket science, honestly, as to why this or why that, because you have a free fall available in a 230 route as opposed to buyback or dividend. And there are regulations, right? How much you can pay, you do that, do this. Everything is micromanaged in a buyback scenario or a dividend payout scenario, correct?
Any questions that need to be answered?
Take it next.
Yeah, there is one more question is there.
Yes.
Section 66 states about cancellation of any paid up share capital which is lost or it is unrepresented by available assets. Can this be explained by way of an example?
Yeah, it can be explained. So if I am a company and the company say it's a cement manufacturer, for example, partially or wholly the factory is destroyed in fire or whatever. And I don't see any reason why I should continue to serve the equity capital, for example, in such a scenario. And therefore, I will want to reduce the capital in view of such a situation which has arisen, force majeure, etc. Or there may be some contractual defaults, EOD pursuant to a contract or pursuant to an arbitration award, etc. And such capital is not represented by an underlying asset in the balance sheet of the company, and therefore I will want to pay back the capital. Because see, in such an example, let's understand what happens in a capital reduction. What happens? The liability side capital, if reduces, the asset side also should get reduced, no? Because balance sheet needs to tally at the end of the day. Now, in this fire example, if there is land and building which is getting destroyed in a fire, obviously it will lead to the value already recognized in the balance sheet of the company, and therefore I will need to also provide a corresponding entry which will lead to reduction in capital, because I will have to recognize the assets differently post such an event. And this can be an example where equity capital is not represented by underlying asset, and therefore I will want to pay them back to the equity shareholder. Thank you.
And one more question is there. Payoff of any paid up share capital which is in excess of the wants of the company, how is this reduction different from buyback?
With regards to how can this process be used to cancel the shares of many untraceable shareholders, as Mr. Yogesh has already told, that it will be covered in the coming slides, and also with regards to minority squeezing out and everything will be covered in the coming slides itself. So let's just wait for that part.
Sure.
Can I put a supplementary to Mr. Chande on this destruction of assets because of fire? If this happens in a well-established profitable company with sufficient amount of reserves, would they not put this loss debited to the reserves or debited to the profit and loss account rather than going for reduction of share capital? In fact, going for reduction of share capital would be a means of sort of camouflaging the loss and taking a hit on the P&L account, straight away going into reduction of share capital, which I feel is a bit unfair. If you're a well-established profitable company with huge reserves, and maybe 2%, 5% of the assets are lost in a fire, take it to the reserves, take it to the P&L account.
I agree with you, sir. Yeah. See, okay, let me rephrase my example. Let me put it this way. You are right. In such an example, first and foremost, there is no obligation. Let me put it this way: to just because some event has happened, there is no obligation or law which says that, okay, now by the way, let's go and do the capital reduction. I'm not saying that. I'm saying it's an option available. First and foremost, if such an event arises, a commercial call needs to be taken from a going concern perspective, from a company's business perspective. You will obviously have a consultation with statutory auditors, etc. And there are tax issues as well, right? Which is secondary. But having said which, if such an event occurs, whether it makes commercial sense also to consider capital reduction or go down that route, that will have to be explored, sir. You are right. So what you said is also an option. I agree with you, not disagreeing at all.
I would go one step further. I would say that if they go in for capital reduction, it would tantamount to, into inverted commas, window dressing or camouflaging or something like that. Because what is truly a hit on the P&L and on the reserves is being taken aside and shown as reduction of capital.
Yeah. So let me rebut that.
Yes, please.
You are right. Yes, it can tantamount to window dressing. Now, see, sir, there is no, first and foremost, as a process, we will always have a resolution and more importantly, an explanatory statement.
Yes.
Presenting the facts, that what is the background and why, what is the rationale for a capital reduction. That is one, whether under 230 or under 66, which is an application to NCLT, where you seek shareholders' approval. You are right. if you are a shareholder, you can definitely contest and you can say, boss, this is all fraud. Let me use that word. This is fraud. This is window dressing. But having said which, sir, as we all know, there are several judgments, Sandvik Asias of the world and all that. What has court said? That yes, as long as this is a domestic affair and blah, 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 we all know that. I will not bore the audience with all that. If fair value is given, etc., what is your problem? Practically speaking, you as a shareholder who is taking this stance, you can always not approve the resolution, as opposed to there are other shareholders who may ride with you, or you who may not want to agree with you and still go ahead and approve the resolution. And let's be honest to ourselves, sir, at least hand on heart, I'm not aware of closely held companies, but widely held companies, listed companies, no matter how much man hours go in drafting these documents, people rarely read them. So if you are an educated shareholder, you will definitely come up with such an argument. Then obviously it has to be contested before Nclt, where let them adjudicate who is right, wrong, or send the matter back to the shareholders, etc. But yeah, all I'm saying is commercial merit. It should merit commercial reasons, whether a capital reduction is warranted or not, to begin with, subject to a particular event happening.
I just wanted to add what Mr. Chande had just mentioned, that this is one of the mechanism which is permitted, that where you can go for such kind of reduction which is not represented by an asset. So it's one of the mechanism which is permitted under 66. When to use, how to use, and what are the circumstances can change from company to company, or Mr. Chande have explained. So for the benefit of the participant, is one of the mechanisms which can be used and can be explored. So that, because section 66, the way
Can
it
you
has
keep
been
the
drafted
mic?
is,
Can you keep the mic out, please? Somebody cross-talking is happening.
yeah. So the section 66 has made it quite inclusive in terms of the manner in which the companies can go for reduction, and that manner does definitely include this kind of what do you say, mechanism permitted.
Thank you.
There's another thing which has been put up here. Few exceptions like HMT Limited under section 66.
So coming to the next is alteration of share capital and reduction of share capital. This is a brief concept based slide wherein, you know, the difference between alteration and the reduction has been given out. Here, the alteration of share capital is a wider concept than the reduction of share capital, wherein you can increase the authorized share capital, you can consolidate larger amount per share and divide in form of, you know, shares of at an earlier price of one share was rupees per. So like in this, for example, if that earlier price of one share was 10 and now the company can increase that share price to rupees 50. So basically this is a larger consolidation happening, wherein the capital of the company is not directly affected. The whole structure of the remains same. Only what we can say is internally the things have, you know, changed. By one of the other is like by converting all paid up shares into stock, and then also reconvert the same, or subdividing the share, which is all, I mean, this stock and everything is redundant basically. And this is a basic, you know, the differentiation between those reduction of share capital in the process. Yeah, here these are not considered as reduction of share capital. This is a reduction of share capital, not considered as a reduction of share capital under section 66 basically, wherein diminution of share capital by cancelling of the unsubscribed share part of issued capital, or the redeemable preference shares, buyback of shares, forfeiture of shares. Even though this is amounting to reduction of share capital, the process followed here won't be you know, under the section 66. So these are some exceptions to the part. One thing here that I would like to add is redeemable preference shares, wherein it says that it is not considered as a reduction of share capital under section 66. I'd just like to, you know, take you to a slide here. So here, wherein the preference redemption of redeemable preference share is considered, there have been a judgment passed recently in Birla Finance, Birla Global Finance Limited, one of the judgments, wherein it was held that a reduction of share capital or a redemption of redeemable preference shares can also be done under section 66. Now, there are two provisions already given under through two routes through which redeemable preference shares can be carried out. One is under section 55, which says that it can be out of the surplus or the distribution of profits that is already available, or by the proceeds of fresh issue of shares. Secondly, the court in that Birla Global Finance judgment, it was affirmatively held that the company can also in any manner. So when, as we all know, that preference share capital already forms part of this, the share capital of the company. So when that has been redeemed, the company, so as said before, the section 66, which provides modes of reduction of share capital, it has given only an illustrative purposes. The company can reduce its share capital in any way, which way possible, which also gives powers to the company to redeem its shares, redeem its redeemable preference shares under section 80 also, given the conditions or the aspects with related to reduction of share capital under section 66 has been followed. So basically, this is where the case where the company wants to redeem its redeemable preference shares, wherein it has no surplus available with the company. So this is one of the few aspects that I wanted to cover here.
I think we can take question. Mr. Yogesh has joined. Now that questions we get. Mr. Bala, you can take the question.
Yeah, the question is here. Few exceptions like HMT Limited did a reduction of the capital approved under section 66. That is the question.
No, I think that is Dipti ma'am, I was always here. Thank you so much. I luckily had no connectivity issue. Thank you. But Bala sir, I think that was a response to what I said earlier, that listed companies typically don't go under the 66 route. But thank you for that information about HMT. I would request the person who has provided this precedent, it's helpful. I would love to see a private sector precedent, because HMT, for everybody's information, is 93% held by President of India. I would love to see a private sector precedent. I will clarify, I am not denying that section 66 cannot be adopted as a route by a listed company. I am not saying that. I am just saying, and now here I will bring another nuance. Dweep, if you may want to quickly look at the 10th March 2017 SEBI circular dealing with schemes. Now I will tell you why I say what I said earlier, including why I will not be appealed. Why I will not be appealed too much with the HMT, which is again a private public sector precedent. Because because the promoter shareholding is 93%. If I'm a private sector company, I dare say you that you will receive stock exchange approval where they will say, boss, आपका MPS compliance ही नहीं है, forget about other things. So that will be the starting point discussion. So let's be real, and in looking at examples also, because private sector, public sector, the color of conversation changes with stock exchanges and with everybody. So if you can pull out the 10th March 2017 circular, those who may already have, I will tell you. See, if you read the 10th March circular carefully, the page 1, point number 2, line number 2 says regulation 11 of listing regulations inter alia provides. Now mark the words. Any scheme of arrangement, amalgamation, merger, reconstruction, oblique reduction of capital, etc. Now the way I read it, it says scheme of reduction of capital. It doesn't use the word application for reduction of capital, first and foremost.
Correct.
So yeah, sorry, I was getting a call. So to define, this circular does not deal, strictly speaking, with section 66. Yes, because it says scheme of reduction of capital. It does not say anywhere the
application
happens to a section 66 application. That is one.
Correct.
Therefore, I said what I said, that I don't see typically listed companies adopting 66 as opposed to 230, because procedurally, if you see the checklist of exchanges, etc., and all, including this circular, for grant of in principle approval, you have to submit draft scheme to stock exchanges.
Correct.
before filing it with NCLT.
NCLT.
Yes, I keep breaking my head that whether it is possible for a listed company to file draft application under 66 to stock exchanges and then grant them in principle approval and only then go for shareholders approval, and post which NCLT comes into the picture.
Right. So the easy
So
way
I'm just
out
saying.
here, so the easy way out here that listed companies do follow is delisting. If they ever want to delisting, like
Delisting.
yes, like what happens
So,
is, even if you add by all the turmoil that you proceed in the court and somehow you succeed towards the end of it, the last question that needs to be answered is the shareholder approval, which in the case of this listed companies, the minority shareholders are in such proportion that they hold such an insignificant amount of number of shares that the only resort available to them listed entities would be only delisting of the shares.
So I'll tell you that is not possible. You can
Yes.
try. Please consider exploiting it, and if you are able to succeed, let me know as well. I'll tell you the
I'm saying that is the only resort available to then the listed entities in case they want to proceed with the reduction.
Yeah, no, I don't think so. I will disagree with you, and I'll tell you the problem. See, the only scenario in India where you can cross 75% is pursuant to a open offer under takeover regulations.
Correct.
If I am an acquirer, say Dweep is the 75% promoter, if there is an outright purchase by me of your shareholding at 75% and I enter into an SPA with you, I do an open offer for the balance amount, say I jump to 80%, for example. That's the scenario where I am legally permitted to breach and cross 75%, correct?
Correct.
Now the provisions are very clear. SCRR read with takeover that within 12 months period, you have to dilute the 5% in my example, which I gave you.
Correct.
So therefore, any corporate action, generally speaking, if you wish to do, you will be faced with this problem that you are anyways at excess. So either you take SEBI approval, seek extension for 80% holding, or come down.
Correct.
Now, generally speaking, you will come down. Therefore, now assuming you want to launch, as you said that at 80%, I want to launch a delisting, correct?
Correct.
Under the delisting regulation, one of the milestone involved is seeking in principle approval of stock exchanges even prior to dispatch of the shareholders' notice. I mean, I can tell you hand on heart, you will not get it. Matter at the most will be referred to SEBI. They will say, sir, hold on, we have referred the matter to SEBI because you are at 80%, you want to launch a delisting offer. Forget your underlying thought process, rational, etc., etc. Just the only example which come to my mind is of a May 2017 SAT judgment of Khode India Limited. Look at it, interesting judgment, KHODAY, Khode India Limited. So my limited point is to conclude whether at 80% you can avail delisting, or for that matter a 230 capital reduction, because even a 230 will require in principle approval of stock exchanges. I can very well tell you, you will not get the stock exchange in principle approval.
Sir,
I hope that answers.
In your example. Sir, so to continue your example of the takeover, na? So in that SST, there is a regulation which says if at the time of disclosure, open offer, if the acquirer discloses intention to delist the company in say for 12 months, then also the delisting can happen if it is clearly disclosed in the open offer.
I think probably you can continue, let him join.
So just on the lines of the current position and the previous position under the 1956 Act and the 2013 Act. So this is basically the reduction, the scheme of compromise and arrangement that was covered in the pre-2013 era, wherein there was specifically a rule under, just a minute, the company's court rule 1959, wherein rule 85, compromise or arrangement, it exclusively stated that whenever a compromise or arrangement involves a reduction of capital of the company, the procedure prescribed by the Act and these rules relating to the reduction of capital and the requirements of Act and these rules shall be complied with before the compromise or arrangement so far as it relates to reduction of capital, which means that whenever previously the company intended to do a reduction of share capital, be it under 230 or be it under section 100 of it, section 100 of 1956 Act, the main criteria beforehand, even to proceed with the court with regards to section 230, the main petition had to be, before you file the petition, there has to be an application along with this 230, wherein you are specifically asking for a approval under section 100, but on a different basis. What has changed after 1956 is of the view that there have been judicial pronouncement and observations with regards to this, wherein the courts have held in Manikchok and Manufacturing Company Limited, wherein the Gujarat High Court held that a court can, while sanctioning the scheme, sanction reduction of share capital. The important thing to find out is whether the procedure for reduction of share capital, wherever it is mandatory, has been strictly carried out. Whether it is directory has been substantially complied with when the capital is reduced by cancelling paid up share capital which is lost or is otherwise unrepresented by the available assets. So it is not mandatory to follow the procedure prescribed in section 101 unless the court so directs. So basically what the crux of the matter is that pre-2013 in the 1956 Act, it was a clear provision that even if you want to go on to under 230 arrangement, there has to be a separate petition filed for reduction of share capital. Unlike which, basis of these katina of judgments, there was a new provision made through 2013 Act, wherein the 2013 Act allowed the petition, 230 petition, to have reduction of share capital as a part of the scheme itself. So which eases out the process of the 230 arrangement, wherein you don't need to separate approval for the same reduction of share capital. It can go along with the arrangement itself, which eases out the process, the litigation process of it.
Yeah, that is a good thing which has happened in the 2013 Act, because everything is brought under one single window clearance.
But surprisingly, there was another judgment passed by the NCLT in 2018 in Art System International Limited, wherein the company, the NCLT, held that it is still under, if it is under 230, you will still require a separate petition to be filed for reduction of share capital, which was for obvious reasons, decided by the NCLT otherwise, and they directed the NCLT to reconsider what they have already passed. So it was a big surprise that NCLT took this view again. Just coming to the next point, selective reduction of capital. So this is where Mr. Yogesh was also the view that he wanted to give an input on. Selective reduction of capital, as far as that is concerned, whenever reduction of capital is involved, reduction of the some proportion of shares of the company on the similar terms and condition offered to each shareholders has been given out. As in, if you and I are the same shareholders in the same class, we will be given the same terms and conditions in order for that reduction to take place. But what happens in selective reduction is that the terms and condition have been differentiated between the shareholders of the same class by resulting in the compulsory extinguishment of the liability of some shareholders while leaving the other shareholders untouched. So this per se looked like a matter where the court would look like this is unfair to the other shareholders who have not been forming part of the the same terms and conditions. However, also in the previous presentation, this question was asked wherein some shareholders were to be reduced, their shares were to be reduced, and some were untouched. So basically, answering to those facts, in the case of Reckitt Benckiser India Limited, Delhi High Court had enumerated some principles wherein it had said specifically that reduction is a private concern of the company. It is a domestic matter for the company. And if the majority has voted for reduction, then they also have the power to choose how such reduction is to be carried out. That is in any manner. That is emphasized in section 66 itself, wherein the majority can decide as to if they want to make a differentiation between the same class of shareholders, be it what. Secondly, the most important is that the court is only of the view and only of the powers to check if that said reduction is fair and equitable to the other shareholders who have not been touched. So basically what we're saying is that tribunal will only see if the scheme is just and equitable and not the motive of the reduction. It only has to satisfy that the interest of the creditors and the shareholders has been safeguarded and secured. Nothing else with the matter with regards to differentiation in terms of conditions or in terms of the offer given to one class of shareholders or given to the same shareholders of the same class. That is still okay to proceed with. I just refer to that question also.
Yeah, one just to add also, the Birla Technologies is also a good case law where selective reduction of share capital was upheld by tribunal against order passed by Nclt. Birla Technologies Private Limited. It's a recent order where a similar question of law was discussed, and their appellate tribunal has upheld the. Of course, they have relied upon this case law of Reckitt Benckiser also the principles, and also have there also they have discussed some of the aspect where the company had some non-compliances, etc., and where they have also upheld that these are matter of domestic nature and can be compounded separately. So just for I'm just posting the name of the case law also in the chat.
Thank you so much.
There is one question which has been asked here. How can this process be used to cancel the shares of many untraceable shareholders and buying out the minority shareholders to make the company wholly owned subsidiary?
I believe Mr. Yogesh was also of the view that he wanted to discuss of this on the practical aspect of it.
Yeah, so 2-3 things. Birla Technologies, the April 2021 judgment also had facts where there were shareholders untraceable. So the way to structure it is, yes, there are untraceable shareholders. What you do is, obviously, therefore, the meeting of shareholders, rather public shareholders, non-promoter shareholders will be of those which are traceable. That is one. So I presume they will pass it with overwhelming majority here because at the end of the day, they are getting liquidity of something which is a dead stock otherwise, which has no liquidity available. So they are getting an exit opportunity. That is one. For untraceable shareholders, one can consider structuring it where the amount payable to the untraceable shareholders, the total number of shares multiplied by the exit price, you park it in escrow account, say for another 3 years, 5 years. And as and when somebody shows up, if at all, you can pay them. And that can be a way to, for lack of proper word, way to please the tribunal that this is what we wish to propose. It's fair, this is the valuation report, etc. But prior to even proceeding down this road, you will have to demonstrate that several attempts, efforts, what are the efforts which have been taken to reach out to this category of shareholders which are untraceable. It should fly. Please look at this Birla Technologies judgment. That's what the facts also there suggest. That should be doable. Also, Dweep, coming back to the previous point, what you were Reckitt Benckiser. See, Reckitt Benckiser, Sandvik Asias of the world and Cadbury's were all in their prime days. Not that they are not great companies even today, but they were listed at some point in time. Listed companies post delisting faced with this scenario where they want the subsidiaries to be wholly owned. Because see, at the end of the day, whether we like it or not, there is a nuisance value attached to shareholders who are not part of promoter group. So there is a tremendous nuisance because at the end of the day, even if you are delisted, the company law compliances will have to still be taken place, right?
Correct.
So Sandvik, Reckitt Benckiser, Cadbury's, all judgments are self-explanatory. They are the most celebrated judgments around all of this. One of those structure can be adopted to squeeze out the minority.
Correct.
And typically, as I say, practically, as long as people are getting cash out, they will definitely vote in favor of such a resolution. So I don't think that's a problem at all. And that's where that selective reduction comes into play, because in these examples, when you say selective reduction, it is the non-promoter shareholder which is being squeezed out.
Correct.
Promoter obviously continues. Yes, if there are class of shareholders there, you may want to even have class meetings. As long as you are clear that, okay, fair enough, I am taking this risk of calling a class meeting, although not required, and I am sure that I will get majority of minority approval within that class meetings. Because the downside of that is that if they don't approve, then the transaction doesn't go through. Yes. While we all have quoted Reckitt Benckiser, Sandvik Asia, Cadbury's, etc., well, all this is permissible, but there is one minority judgment of Andhra High Court where also they have taken a contrary view actually. So they have sided with the minority shareholders as opposed to taking a majority view. So, but anyways, I honestly don't see the tribunal or the bench interfering with the commercials of the transaction, as long as it's like if the bride and groom are happy, who are we to unnecessarily poke in between, right? So that's the approach, and which I believe is the correct approach, because at the end of the day, we want to invite FDI and certainty of deal structuring transactions, because more often than not, post delistings, where company becomes a wholly owned subsidiary, people may want to again, after the expiry period, will want to, after 5 years, explore relisting the company. There may be some financial strategic investor coming into a delisted company which is wholly owned. So there are several such transactions where the potential buyer is interested in a wholly owned subsidiary as a financial or a strategic investor, and they don't want any nuisance value pertaining to retail shareholders. So these were the few thoughts. Also, I wanted to add on, I mean, I have seen many IBC cases, insolvency, bankruptcy cases involving listed companies. So there is not much of an hassle, because typically the resolution applicant will have a provision in the plan where the old share capital will be reduced straight away, no questions asked. At the most, it will only warrant some filing requirement here and there with ROC, which is fine. But there is not much of an hassle even in an IBC scenario, whether listed, unlisted, etc., where capital reduction is pretty straightforward.
Even stock exchange, only a disclosure is required under that if there is a resolution plan coming up, and there is no requirement of
sending that scheme or for approval with regards to the stock exchange concerned. Correct. Yeah. So there are several amendments done in multiple regulations, the delisting, takeovers, etc., preferential issues. Certain provisions apply, some provisions don't apply for a Section 31 IBC. But coming back to the capital reduction, yes, you are right. Stock exchanges in a listed scenario at least have issued several guidance notes around it, what needs to be disclosed, and etc. So which is fine. But I mean, nothing else unless somebody has any question. Thank you so much.
I think somebody has put an information, I think, so it's not a question. In the recent case of the Vedanta, extinguished lost unproductive asset book value by reducing the reserves instead of the capital. I think this appears to be the information.
Ala,
yeah.
In this case, should it not have been debited to P&L rather than reserves? You know, these companies, they don't want to take anything to P&L. Directly into reserves. I would say it should have gone via P&L account into reserves.
So, sir, again, we are going into the territory which we discussed, that this should have been done, that should have been done. So let me explain this. I will try to throw some light around it. See, reduction of reserve, unlike a reduction of equity share capital, what it does, post the reduction, if my shareholding goes down, the dividend payout is subject to the number of shares held, right? Linked to the face value, unlike in a reserve scenario where there is a reduction of reserve. So it's a commercial call again, because sir, if promoters are also for that matter, even let me put it this way, if the shareholders are relying on dividend income, they are better off reducing the reserve as opposed to reducing the capital per se. So perhaps that may also be a commercial reason and consideration how you structure a reduction. Yes, there is.
Just to give you a parallel example, see, companies always want to avoid debits on P&L account. And in the past, in the case of ESOP issues, the debit is in the case of ESOP issues, the debit would go directly to the reserves. Thereafter, legislation was introduced which compelled the companies to take it via the P&L account. This is one of the ways which companies use to keep a good picture in the P&L account. One does not really notice the reduction in reserves. I agree that the ratios would have the same impact, but a reduction or a sharp drop in P&L account is more obvious than a drop in the reserves, and therefore companies resort to this. But here, let me appreciate Vedanta having gone at least to reserves and not gone into reduction of share capital.
Yeah, and sir, let me say one thing. See, market is smart than all of us. Please see the data point, which is when this reduction was announced, what was the stock price then and what is the stock price today, even after the bloodbath which is there today. So market is smart. People who are invested are more smarter than all of us. At the end of the day, I will again repeat, as external advisors, as company secretaries, lawyers, etc., we are at the most doing what? We are at the most trying to comply with law, process, etc. As I mentioned earlier, sir, there is more than what meets the eye, in the sense that there are several commercial implications, accounting, taxation, etc., which needs to be considered before going down this route. So nothing wrong as long as they comply with everything. But I'm saying, yes, you are right. It is worth exploring, but there are several other considerations, which we all know, right? Apart from following Companies Act.
That's another question which has actually come up. In case of the right issue, where the shares are unsubscribed, and as a result, the issued capital would be higher than the subscribed capital, then can it be diminished or cancelled, and how?
So the query honestly is not clear to me, at least, because is the question that how do you combine the cancellation with rights issue, or post the rights issue you do cancellation?
Shivkumar, are you there? Can you speak actually? Can you make it a little clear, your query, please? Shivkumar?
Hello.
Yeah.
Yeah, am I audible?
Yeah, very much.
Yeah, it was on that point where we said the diminution of, there is one way which says it is not a reduction of share capital, where we say diminution of unsubscribed, where it is in issued capital. So normally what happens is, if there is a rights issue and you have an issued capital and it is not subscribed fully, then your issued capital is more than the subscribed capital. So in that case, do we say it is a diminution of capital to bring down the issued capital to the level of subscribed capital? That was my question.
So your question, sorry, please go ahead. Sorry.
Yeah. So what I'm saying is, suppose if my issued capital is say 100 and the subscribers have only subscribed say 75. So in my balance sheet, the issued capital will be 100 and subscribed will be 75. So if I want to bring down that to 75, so can I use this route, or will it be tantamounting to a diminution of capital? And if at all, what is the process? If at all, it can be done.
So Shivkumar, in any rights offer document,
Yeah.
the letter of offer very clearly disclose, right, what happens to the unsubscribed portion. So whether, just to give you a very simple example, listed company, it very clearly says that promoter will take care of the unsubscribed portion, if any, right? Or so I'm saying such a situation practically may not arise unless I'm missing something. So because the letter of offer upfront will state what happens to the unsubscribed portion. So it's not that it lies in vacuum in that sense. Correct?
Let me come to Shivkumar's
question. Yeah, please.
I think what Shivkumar is talking about, if you make an issue of 100 rupees and only 85 is subscribed, then the promoters come in and put in 5 and take it to 90 so that the issue sails through. In this situation, you have a gap of 10 because what is subscribed is only 90 and not 100. And therefore, all future balance sheets will show issued capital, 1,100 and paid up capital 1,090. In this case, if the company wants to bring issued capital and subscribed capital to the same level, you have to go through reduction of share capital. Am I putting your question right, Shivkumar?
Yeah. So Amber here, I'll just add, I think such cases need not go through 66. I think 66 will typically come when you want to extinguish your liability under the paid up capital aspect or uncalled capital and all those. So these parts will not require under 66. That's my view.
My humble view here is, and I may be wrong, mere board resolution may be sufficient for doing this, for reducing the subscribed capital to the issued capital to the level of subscribed capital. You need, because it has really no meaning, that issued capital.
No, not only that, sir.
I agree with
my point is, first and foremost, has anybody seen a letter of offer for rights issue where rights issue is commencing without stating anything in relation to who will subscribe to the unsubscribed portion? I think first question needs to be answered is that, because only then you'll end up in this situation, right?
No, the promoters need not necessarily take up all. They have to ensure that the issue goes through. That is the minimum issue amount, minimum subscription amount is subscribed. So they undertake to do that. They don't undertake to 200%, take it to 100%. Why
Correct.
should they?
Correct. No, I'm not saying there is a compulsion. I am only asking a question.
Yes.
I'm not at all saying it is binding on the promoter to subscribe to the unsubscribed portion. I am merely saying that has anybody seen such a situation, that is one where the letter of offer is silent about unsubscribed portion. Second, in fact, I would then suggest that rather than lending in this situation, you, before starting the rights issue, why would you not reduce the size of rights issue? And from 100 come to 90 and 90 is your new 100.
No, this happens subsequently. The people don't take up, or this would even happen in a public issue, not necessarily in a rights issue.
In fact, in the right issue, I have seen in the past some documents where it categorically spelled out, as our panelist said, that whatever the unsubscribed portion of the right issue will be re-allotted to the shareholder who wish to subscribe such unsubscribed shares. That's sort of the condition I have seen in the right issue.
Exactly, sir. That's what I'm saying. You are right. Yeah. That's what I'm asking.
And the document very clearly said that they will re-allot this to the unsubscribed portion in the proportion of the shareholding held by the shareholder. That was the document which I have seen.
Exactly. So this query is stage 2. At stage 1, I am saying whether stage 2 will even arise, because stage 1 is what disclosure is made in the letter of offer. Correct. Anyways, I think coming back to the query, we got the answer that this does not necessarily have to go through section 66 route. I think that's the answer, right?
That definitely is the answer. But then if we want to bring issued capital and subscribed capital to the same level, what would be the process? It's a very interesting
Shailesh bhai, it's near to 1 o'clock.
Okay,
still query.
All right.
Still query is there.
Okay.
Still query is there.
Okay.
Mr. Bala, pending.
Can
Mr.
selective
Bala
reduction,
pending queries.
can selective reduction of the capital be applied for reduce the physical share so that there are only demat shares?
Oh, this query is not clear. I mean,
So it
No,
appears-
I got it.
Yeah.
So I got the query, but I think yes, you can, but I can definitely expect pushback at the tribunal level. If we can, the querist please clarify: are these physical shareholders untraceable or are they traceable?
No, the
Okay,
physical
anyways.
shareholders are traceable.
Okay, so sir, that
The
will
company wants to reduce the physical shares.
Then they
Yeah.
have to ask,
Eliminate.
them. Then they have to ask them to convert into demat.
It's very
Because-
difficult to demat nowadays.
No, sir, Mr. Vesavia, Yogesh here. So I'll tell you, sir, let me put it this way. I think this is, if you are now saying that they are traceable. So honestly, this is like putting gun on their head.
No, they take
Okay.
my case. No, take my case only. I've got so many shares physical where cost of dematting will be more than the cost of the shares.
Sir,
There'll be
but
many
that's
such
like,
small shareholders.
no, I agree, sir. But sir, it's like saying that if I am company secretary in your company, it's difficult to calculate a remuneration and I will therefore not pay you the remuneration. That can't be the analogy, no? So my limited point is, you can try. I expect pushback on this. It's like putting gun on the head, and honestly, I don't see this passing the muster. And more so, such a reason where people say that okay, cost of demat is more than my fair value of the underlying shares, etc. and all. I don't think this will fly, because then this will open floodgates. Just imagine your intention is to do this because the cost of demat is more. But then this open floodgates for various others where I say I don't like your face and I want to reduce you. Then I will do this. So then this open floodgates at a policy level. I think this will set a bad precedent. It's like putting gun on their head. You are right. You will now say that okay, I'm having their consent. But then this goes down the route of shareholders democracy, and it starts all those discussion and debates around this. You can try, but I don't think this will fly.
And there's one more issue with dematting also again. Most of the times the demat request gets rejected due to signature difference, this, that, so many, the name.
I
like
think,
in my case,
I think this
the
is
father's name is
practically,
initial.
I know, I think this is a practical issue to be dealt with the company as such, not for reduction of share capital.
Sir,
So
sir, in your fact pattern, is it mandatory under law to hold shares in demat only?
Now SEBI is encouraging everybody to hold in demat. So now
So, sir,
everybody has to do.
so, sir, exactly, that's the answer, right? You are saying SEBI is encouraging as opposed to SEBI has mandated it.
No, they're
So there's a difference.
literally making it mandatory now.
Oh, in
No,
listed
sir.
company, it is mandatory. In listed company, it is mandatory.
Yes.
Correct. So, yeah. So, sir, that's what I'm saying. So you can perhaps try that. You can use that as an handle. But honestly speaking, I don't see it passing through the muster. I mean, you can try. You can speak to some senior counsel who regularly appears before the tribunal, how this will be viewed.
There is another information has been provided. I think it is not the question. Birla Technology is also another good case for the selective reduction of the share capital, which was upheld by the Nclt in appeal against the Nclt order. That's
Yes, sir. We touched upon
so
that.
I think you touched upon this earlier.
Yeah. So I posted that case law for people who want to know about.
Okay. Then somebody is asking, impact on the reserve, please elaborate.
That we have discussed already.
That I think we discussed that.
Yeah.
Then the next thing is reduction of the capital in material subsidiaries were approved by the holding company shareholders. Now, which is required, though recent amendment in SEBI LOR, that is welcome move. What is your view, sir?
No, so sir, anyways, shareholder approval is required, whether material, not material. So if you are a holding company, so that is very much required. So anyway, that will get covered.
Okay. Right issue query. Passing a board resolution is
that we have discussed.
That I think we have discussed this.
I think we have done with all the questions now.
Yeah, I think so. Any more questions, or we can close this session?
We can close, ma'am. Thank you very much.
Thanks. Thanks, Mr. Yogesh, Mr. Ambar, Mr. Bala, Dweep. Very
Hello.
good presentation, deep insight. Thanks everyone. Thanks a lot for all your participation and time. Thank you, everyone.
Thank you.
I must definitely thank for the presenter. Definitely, he has presented the physical aspect of going to the procedural issue, etc., and other things and all by giving the form, what is the content, etc., and other things. It will be definitely a knowledge empowerment for all of us. Thanks a lot to everybody for your sharing the knowledge. Thank you.
Thank you, everyone. Thank you, Yogesh.
Thanks.
Thank you, Dipti ji. Thank you, Mr. Bala. Thank you to
Thank you.
Mr.
Thanks,
Joshi for
everyone.
putting up such a nice presentation. Thank you, sir.
Thank you.
Thanks, Mr. Yogesh and Ambar. Thank you. Bye.
Thank you.
Have a good day. Enjoy your Sunday.
Yeah.